Hi everyone, welcome to another Foyle Island online event, and I'm delighted that we have Ciaran Lewis SC with us today, and he's going to be looking at case management and pre-trial protocols in non-personal litigation. So just to introduce myself, I'm Ian Thornhill, the Ops Manager at Foyle, not Lawrence Bessemer, as I know it says on the screen. I'd also like to highlight another Foyle event, a Foyle Island event that we have coming up, which is an in-person event at RDJ in Dublin on the 4th of December, where we have Lisa Kelly BL on quarterbanks, tenders and costs implications of failure to mediate. And also we have Shane English BL, who will be speaking on defamation claims. If you want to register for that event, just look on the Foyle website, www.foyle.org.uk, and head to the members section, then calendar, and you can find the details there. If I can ask you to make sure your microphones are on mute, that would be great. Any questions that you have for Ciaran, if you can use the chat facility, and we'll try to get through as many as we can at the end, time permitting. And just to let you know, your CPDs will be sent to you by email, probably next week now. But without further ado, let me hand you over to Ciaran.
Good afternoon, and thanks very much for joining. Unfortunately, I haven't been confident enough to manage to share my slides, so Ian's going to very kindly run the slides from his end.
Hopefully you can see them now. Is that okay?
I can see them, yeah. Hopefully everybody else can.
Good.
So, yeah, the topic is case management and pre-trial protocols in non-personal injury litigation. And I'm going to give really a personal view of case management and how it's developed over the years since I came to the bar. So I was called to the bar over 25 years ago. And before or when I was called to the bar, there wasn't really any case management to speak of. Just before I get into the meat of it, Ian, if you don't mind going to the next slide. I think it's important at the outset just to emphasize that what we'll be dealing with today is case management in plenary actions and other types of plenary proceedings, as opposed to other types of case management. So there are a number of different lists in the Irish High Court which people will be familiar with, like the Judicial Review list or the Planning and Development list and the Asylum list. And those are all lists that really deal with cases on affidavit where there is no discovery. And I think that the problems of case managing those types of cases are much less acute than trying to case manage plenary actions where you're going to have oral evidence and you're going to have significant interlocutory applications like discovery in some cases, or jurisdictional challenges, or any number of different types of injunctions. So what we're talking about today really is case managing plenary actions. And historically, as I said, over 25 years ago, there was no real case management. If you don't mind, Ian, going to the next slide. There was really two lists where plenary actions could be found. One is the Chancery list and the other was a non-jury list. And what the case management consisted of was every term, the judge in charge of each list would have a list of fixed dates, and on that date all of the cases that were going to attempt to get dates for hearing in the following term would be listed. Back then there was no electronic legal diary. There was a printed legal diary which appeared on an A2 sheet, and on the dates that the list of fixed dates were on, all of the cases that were going to attempt to look for a date for hearing in the following term would appear on that list. Inevitably, there were more cases than there were dates available. And this resulted in really ferocious battles to try and get your case on for hearing. And because the number of slots for hearing cases was always less than the number of cases looking for dates, the call over to fix these cases for hearing would be held in either a chancery court or a non-jury court. And the first problem you faced back in those days was actually trying to physically get into the court, so that when your case was called, you'd be able to tell the judge that you wanted it to go on. The courts would really be jam-packed. And once you got into the court, there was always going to be a number of areas of controversy. The first was probably going to be a row with the other side about whether or not the case was ready to go on. Inevitably, if you wanted your case to go on, you'd be telling the judge that everything was done. And inevitably, whoever was on the other side would be telling the judge that something was outstanding, there was no replies to particulars, or there were further discovery queries being raised. And the second controversy that would generally arise was, what was the length of the trial going to be? Because if a party didn't want a case to go on, inevitably they would probably try and tell the judge that this was going to be a very long case, and therefore it had less chance of getting assigned a date. If both parties were anxious to get a case on for hearing, they would generally probably tell the judge that the case would take shorter than it really would. And the problem for the judge was that the judge would have no knowledge at all about what was involved in any of the cases. So there'd just be a list of cases that where certificates of readiness had been issued by counsel saying that they were ready to go on. The judge wouldn't have read any papers in advance. The judge wouldn't know how many witnesses there were. The judge would probably know very little about the case other than what counsel would tell them on the morning. So when I was Devling, I was very fortunate to have a very kind and encouraging master, but he was also very busy. And for me, that meant that when the list of fixed dates were on, I'd have a pretty stressful morning. So I'd have to go to his office first thing in the morning. He'd give me the legal diary. He'd have highlighted on it, on the physical paper, all of the cases that he was in. And then he'd have dates scribbled beside them, indicating what dates he wanted me to try and get for those cases. I would know nothing about the cases, or next to nothing about the case. And so you had to run the gauntlet of, first of all, getting to either the chancery list or the non-jury list, forcing your way into court first, and then from the back of the court trying to argue about whether a case was ready to go on. From time to time, you might get lucky and the judge would assign one of the cases you were looking after. But if that didn't suit any of the dates that I've been given by my master, I'd have to kind of suggest maybe the judge might give us a different date, which usually resulted in an explosion from the bench because there was such pressure on to get cases set down for hearing. And the response was, look, we're not here to accommodate counsel, you've just got to get on with it. So it was a pretty stressful time. It was made worse on one occasion by the fact that my master was doing a number of cases with a very prominent senior counsel, and she happened to be extremely intimidating. I suspect some of the people on this call probably know who I'm referring to. She subsequently went on to become a Supreme Court judge, and she didn't suffer fools. So on one occasion, when I had been sent in on a list of fixed dates by my master to get his cases listed for hearing, I also had to get the cases that he was a junior in with this senior counsel listed. And she was very particular about the dates she wanted for her cases. And she was very particular about ensuring that she didn't get a clash with any of her cases, so that she wouldn't have a chancery case or a non-jury case listed on the same day. So I got through the morning, and I managed to get into the non-jury list and into the chancery list. And I eventually got out at lunchtime. I was very proud of myself, having got all of the cases assigned dates, which was a pretty good achievement. And I was walking down the corridor when I bumped into the senior counsel. And she stopped me and said, this is the best impersonation I can do of her without disclosing her identity. She said, now, what date did you get for XVY? And I said, oh, very proudly, I said, that's 16th of February. And she said, very, very good, very good. And what did you get for WVZ? And as I fumbled in my papers, I realized that I'd also got the 16th of February for WVZ, which resulted in an immediate explosion of, you are a very, very stupid boy. And stupidity I'd embrace. That was probably fair. But boy, I was about 25 at that stage. So it was a great relief that sorry, Ian, you might move on the slides because the next one. Yeah, so it was a great relief that actually in 2004, the commercial court was established, and the commercial court was really a revolution in case management. Um, it 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 did some things that now seem self-evident and are really quite simple, but it did them very well. Now, under the rules of the commercial court then, as now, you couldn't get your case in unless it was valued over €1 million, or it had some commercial element to it, or it was a particular type of case, a case dealing with intellectual property, or it may be specific interpretation of contractual provisions. And entry to the list back then, as it is now, was guarded pretty closely by the presiding judge. And that was because, I think, for the court to be successful, and because the court only had finite resources, but for the court to be successful, it simply couldn't manage all of the cases that wanted to get in there. But from its inception, if you managed to get your case into the commercial court, you were pretty much guaranteed that your case would progress quickly, and that when it came on for hearing, you would definitely get the case heard on that hearing date. Now, the idea that there would be any doubt now in a commercial case about actually getting it on for hearing on the date that it's fixed for hearing sounds pretty wild. But under the old system in the Chancery list and the non-jury list, the standard was to list 3 or 4 cases per day on the available dates. And that was done not because there was going to be 3 or 4 judges available, but because it was hoped that at least 2 or 3 of the cases would settle. One of them may get heard, and one of them may have to go back to the list to fix dates again to have another go. But it was extremely unsatisfactory for practitioners and clients alike. If you'd put an awful lot of effort in getting a case ready for hearing, you'd gathered your witnesses, you'd had consultations with clients and so on, only to turn up on the morning of the trial ready to go, to be told there's no judge available and you've got to go back to the list of fixed dates. So the first thing really I think that the commercial court did was not just getting cases ready for hearing, but also ensuring that if your case was ready for hearing, it would be assigned a date, and you'd certainly get the case dealt with on that date. And I think in all the time that I've been practicing, there was only one occasion when I was involved in a case and it couldn't go ahead on the date specified, but it went ahead a week later. The other kind of fundamental things that the commercial list did in case management, which again seemed pretty simple, were to ensure that there were witness statements. So now you'd know what evidence was going to be led against you. You knew precisely what evidence your own witnesses were going to give, and you'd know how many witnesses there were going to be. So that really ended trial by ambush, what would have been the norm in the non-jury and the Chancery lists. It also then, I think, possibly as a consequence of that, helped with the settlement of cases, because this kind of cards up type of litigation allows everybody involved to really assess the strength of the case in advance. So you have a good idea before the case starts, within reason, of how strong or weak the case is. Another fundamental thing that the commercial court ensured happened was that there'd be agreed trial books. And strange as it may seem, back in the old list of fixed dates days, there was no certainty that you would ever get trial books agreed. You might end up running a case, working off different books from the other side, and all of the chaos that came with that. Sorry, Ian, you might just move on to the next slide then. Yeah, another innovation of the commercial court, or it's not really the commercial court, but simply the case management that it affords, I think, is that you can now get complex interlocutory applications dealt with, which otherwise could really hold up a case being ready for trial. So an obvious one now is discovery. Now, whether or not it's a good thing that discovery has become such a big part of plenary trials and litigation, as matters stand, as a matter of fact, it is. And if you have a highly contentious discovery hearing, which is going to take maybe 2 days or 3 days, if you didn't have the case management that the commercial court affords to those types of cases, you're getting the case ready for trial and getting it on for hearing would be much slower. Going back again to the pre-commercial court days, no matter how big or small your case was, the discovery application would always start in the master's court, which could be a pretty kind of summary environment to have important discovery questions resolved. And then if one party or another party wasn't happy with the discovery that had been ordered by the master, you'd end up appealing it. But your appeal would go into the non-jury list or the chancery list, and then the appeal itself would go into the list of fixed dates, and it would have to be assigned a date. So the whole process was extremely slow. So the commercial court being able to say, well, look, there's a problem here with discovery, it's going to be resolved, it'll be resolved on these days, is a real innovation. And it's not just discovery applications, it's really any interlocutory application that the commercial court might have to deal with or that might arise in a case. So there's a good illustration of complex jurisdictional challenges which arose in 2 different cases. The first was in this case of Microsoft Ireland v Arabic Computer Systems. And that was a case where Microsoft were suing a Saudi Arabian company who it claimed owed them about 14 million, I think, of US dollars worth of software. And Microsoft had an Irish contract or contract with an Irish choice of law clause. The Saudi company, although representatives of the company had signed the contract, they challenged jurisdiction on the grounds that the people who signed the contract didn't have authority to enter into a contract. And so the question of ostensible authority came up. And there was a very complex jurisdictional challenge, which involved the questions of whether the jurisdiction clause was valid and whether Saudi law or Irish law would apply to the enforceability of the jurisdiction clause, and whether Saudi law or Irish law would apply more particularly to the question of ostensible authority. The commercial court heard the jurisdiction challenge, which involved, in that case, cross-examination of expert witnesses over a number of days. But it was able to afford that case the luxury of having a significant piece of litigation dealt with in the course of the trial, which didn't ultimately slow it down getting on for hearing. And that case is now resolved. A similar case is the case of Ryanair v Vola, which started in 2017. Ryanair made an application to have the case admitted to the commercial court, and they were refused for various different reasons. But in Ryanair v Vola, Ryanair were suing Vola. It's an online travel agent which has its seat in Romania. And one of the issues was whether or not, by accepting terms on the Ryanair website, which included a jurisdiction clause, the defendant Vola had submitted to the jurisdiction of the Irish courts. There was a very involved jurisdiction challenge which lasted a number of days, and the Irish courts ultimately said that they did have jurisdiction to hear the claim, but that case hasn't come on for hearing yet. That case has been split into 2 modules, and the first module hasn't even been heard. So the likely end date for that case is probably at this stage sometime in 2028. So that just, I suppose, illustrates how two similar cases with complex issues can progress at dramatically different speeds, where one can be afforded proper case management. Ciaran, sorry, you might move on to the next slide. Yeah, I think in the history of the commercial court and the case management that it affords, there are really two significant events. The first was a financial crisis in 2008 and after that. And that spawned a huge number of cases involving a lot of money. And although a lot of them started life as simply debt collection cases, they ultimately grew into cases which posed very significant questions which needed to be resolved. So on the next slide, I think I've identified some of the issues that have been dealt with in those cases. There are questions about the enforceability of guarantees, about undue influence, about penalty interest, questions in receiverships, significant questions in examinerships, questions of contractual interpretation. And a lot of those cases were very successfully and quickly case managed only because of the commercial court. And for example, there was a case of the Quinn children against the former liquidators of IBRC. That was a case that involved some significant judgments on privilege and in discovery, and ultimately was set down for hearing with over 50 witnesses due to give evidence and various complex questions to be resolved. And I think it would have been impossible for that case ever to get ready for trial if it was being dealt with in the normal list of fixed dates case management, if it could be called that, pre-2004. I think the second significant milestone, and I suspect a lot of people on this call would have had some involvement with it, was the Russian aviation litigation. And if you don't mind, Ian, going on to the next slide. Sorry, yeah, I should say before I go on to that, if we just go back to the last slide, one of the problems with the commercial court becoming so efficient was that actually it brought into sharp relief how inefficient the appeal system was in Ireland. It soon became apparent that no matter how efficient your commercial court case was and the case management was, if you got your case dealt with very, very quickly, all the other side had to do was to lodge an appeal and have a row about trying to get a stay on some final order. And then you were going to wait a long time before your case was going to be heard on appeal, because in 2004 and the years following, the only appellate court was the Supreme Court. So that all changed in 2014 when the Court of Appeal was established. And in the years following that, the Supreme Court transferred over 1,650 cases to the Court of Appeal to be dealt with, which gives you an indication of how serious the backlog of appeal cases was at that time. But the second real milestone, I think, in the commercial court history and the history of that case management is, if you don't mind, Ian, going on to the next slide, was the Russian aviation litigation. So high value litigation, 3 sets of proceedings, I think, although someone will probably correct me. I think there was 9 defendants and at least or close to 100 issues identified by the parties. It was complex because, not least because of the number of parties, but because of the policies of insurance that were in contention. Some of the defendants wanted to argue that an all-risk policy responded. Other defendants wanted to argue that a war risk policy responded. And therefore, the defendants were split into at least 2 groups who were really litigating the case as between themselves. It resulted in the plaintiffs falling into the same camp as some of the defendants some of the time, and the plaintiffs then being against all of the defendants on some of the issues some of the time. So it was complex because of the number of parties, because of the number of issues, and because of the nature of the dispute that was being litigated. And on the next slide, I think, just before I move on to that, so that Russian aviation litigation, I think it was admitted to the commercial court in December 2022, came on for hearing in June 2024, and ultimately, after many days of hearing, it was settled, all of the parties settled by March 2025. Now, anybody involved in that litigation will tell you that the case management of it was by no means perfect, and the parties were put under huge pressure to do things probably more quickly than those things really should have been done. And discovery was one example. But at the same time, it has to be acknowledged that if the case management of the commercial court wasn't there, there's absolutely no prospect whatsoever of that litigation being dealt with effectively. So it really did show how important it was to have proper case management. That kind of the success of the commercial court case management leads to showing how inefficient at the same time the chancery and non-jury systems were. So they were existing in parallel with the commercial court cases, and any case that didn't get admitted to the commercial court for whatever reason, or couldn't be admitted because of the rules of the commercial court, would still remain in the chancery and the non-jury lists. And so in 2014, there were 2,149 chancery cases which started that year, and only 775 were concluded in that year. I think that's about 36% of the cases. In contrast, in the same year in the commercial court, I think 93% of the cases that started that year were finished that year, whether they'd been heard or whether they had been settled. So that then led to an attempt to apply case management across all of the plenary cases that were coming before the High Court. And if you don't mind, Ian, just moving on to the next slide. In 2016, there were two statutory instruments that were introduced. One was the conduct of trials, and the other was the chancery and non-jury actions pre-trial procedures. And what they really aimed to do was to introduce identical case management for all of the plenary actions that were coming before the High Court, not just the commercial court cases. And they intended to have a presiding judge appointed with a specific registrar who would manage the chancery list on the one hand and the non-jury actions on the other. And then there was also a facility for the president of the High Court to nominate cases that didn't fall into any of those lists to be managed. The statutory instruments were commenced, and Order 63 Rules C or Order 63C of the Rules of Superior Courts were put into being, if I can put it like that. But immediately after the rules were established, there was a controversy between the judiciary and the court services and I think the government about the availability of resources. And the judiciary complained, I think, that in order to run these rules or to make this case management effective, more judges would be required and dedicated registrars, and that the resources just weren't there. And ultimately, I think there was a notice from the chief registrar at the prompting of the judiciary to say that while Order 63C is now in being, it's not going to be operated because the resources aren't there. And it's actually, as far as I can gather, still a grey question as to whether or not anybody is entitled to rely upon the provisions of Order 63C. And someone may have some information about that in the call, and I'd be interested to know what their views are. If you go on to the next slide, Ian, very briefly, like what the Order 63C provides for is case management on a similar basis to the commercial court. Either party or the judge of the judge's own motion can designate a case that's in the list for case management, and that would give rise to a case management conference, and papers would have to be lodged. There'd be papers lodged providing a chronology and a summary of the issues, all the relevant papers in the case. I think very similar to the kind of book that's going to be lodged in the commercial court. And there'd be a case management conference, and at the case management conference, the judge would set directions. Now, on the next slide, this refers to what happens if there's no, under Order 63C, if there's no case management conference because nobody has made an application to have the case managed. So if your case hasn't been case managed, when you come to the point of looking to have the case set down for trial, there's a mandatory pre-trial conference, is what it's described as under Order 63 Rule C, where the parties are compelled to complete a pre-trial questionnaire, and the leading solicitor or counsel on behalf of each party have to appear, and essentially directions are given by the judge, looking at a book similar to a book that would be lodged for the commercial court with all the relevant papers, to make sure that the case is actually ready for trial when a date is fixed for it. The judge also considers the provisions of Order 39 Rule 60, which relates to experts. And if you don't mind, Ian, going on to the next slide, I think it's an open question. I think the rules are in force, but are they applied? And I've had experience of applications being made in cases I've been in the Chancery list to have the case managed. I'm not sure if it was ever pursuant to Order 63C or pursuant to the inherent jurisdiction of the judge dealing with the list. The cases have been case managed and witness statements have been directed. But it's not clear, I think still, whether actually you're going to be compelled, if your case isn't case managed, to have a pre-trial case hearing. So Ian, if you don't mind going on to the next slide. But what has happened, and I think this makes it clear that case management, at least to the non-jury list, has really been a haphazard, notwithstanding the introduction of Order 63C, is that there's a practice direction, which is High Court Practice Direction 127, which came in June 2024, which is very, very simple, but quite effective, I think, if it's followed. And the Judge Hyland, I think, was dealing with the list back in June 2024. And as far as I know, it was at her insistence that this practice direction came in. But if you apply for a hearing date, the application for the hearing date under this practice direction is treated as a case management hearing. It can be in person or remote. It doesn't matter who's attending. So unlike Order 63 Rule C, it doesn't have to be the senior counsel or the partner in the firm. But the person appearing to deal with the case and look for a date must know something about the case. And that would have been a far cry from my having been sent in as a devil on a list of fixed dates to look for a date for cases about which I really knew nothing. The parties have to complete a trial summary form, and they have to exchange the form, and they have a period of time to agree to what the case is about, how long it's going to take, how many witnesses are going to be, and so on. So I think this High Court practice direction, in my experience, it was being followed. I'm not sure if it's still being strictly enforced in the non-jury list. But certainly the judge dealing with the list at the moment does want to know from parties, if they're looking for a date, how long the case is going to take and how many witnesses are going to be and so on. But I think it just indicates that really the attempts to have some form of formal case management along the lines of the commercial court on a consistent basis have simply failed. Sorry, and you might go on to the next slide for me. Yeah, why is it so difficult, I think, to implement case management in the Chancery and the non-jury lists when, as we see, there's some very simple things that can be done which were done in the commercial court, which really made a big difference to cases. And I think the answer to that is, if you don't mind moving on, Ian, I think the answer to that is simply that while the judge in charge of the commercial list has a discretion about what cases come in, and the judge can therefore control the volume of cases, and the volume will match the resources available to deal with the volume of cases. In the Chancery and the non-jury lists, really, there's no filter at all. There's a constitutional right to litigate and to have access to the courts, and bar repeat litigants who might be subject to Isaac Wonder orders or something like that, there's no control on the number of the cases that come into those lists, and therefore really even to case manage cases on a very basic level is exceedingly difficult because the resources just aren't there to deal with a number of cases. I did want to say something about Order 39, Rule 63, which I have to confess I wasn't aware of until I was doing some research for this talk. And this was one of the provisions that was brought in the 2014 SIs. And this permits a judge, when the parties are both relying on experts, first of all, and as happens consistently now, the experts are compelled to meet and they have to produce a report, and the report has to say what areas of the expert evidence they agree on and what areas they don't agree on. But Order 39, Rule 63 now permits the judge to direct that both of the experts would be sworn in evidence together, and the judge can then ask the experts questions while they're both sworn. And beyond that, the judge can then require the experts to engage in some debate under oath on the issues. And I've never seen that in practice, I have to say. I think it's probably a recipe for utter chaos, and it'll probably be a brave judge who attempted to implement it, but I'd be interested again to hear from anybody on the call if they've come across it. Yeah, finally, or moving on, there are difficulties with case management, I think. First of all, I think that the work can expand to meet the available resources. So if there are resources there to deal with interlocutory applications, it may be cynical view, but sometimes people might take advantage of that and litigate issues that otherwise they just have to sort out amongst themselves. The second problem with case management is that it can give rise, where you have case management hearings or conferences, for parties to engage in skirmishing rather than being constructive about trying to get the case on. Those are occasions where people might try and engage in point scoring or try and colour the judge who's simply dealing with the case management conference at that stage, but try and colour the judge's view against one party or another. The other problem with case management, I think it's an age-old one, is what do you do if there's breaches of directions? And in the commercial court, what you can do is have the case expelled from the commercial list. But of course, this can turn into a license for parties who don't really want the case to be in the commercial court to deliberately breach directions so that the case is expelled and then has to languish out in the Chancery or the non-jury list. Different judges over the years have employed different methods to try and bring errant parties to heel. Some judges, I think, have taken out the big stick and, demanded humble apologies from the solicitors who've been assigned to deal with the case to explain why there have been very minor breaches of directions. I don't know if that's very constructive. Generally, I think that really the best way to deal with breaches of directions is to try and encourage through limited embarrassment. And I say that limited embarrassment advisedly of the parties, to try and encourage them to comply with the directions rather than to have public floggings and executions. The final difficulty, I think, with case management, or what it can do, is to create a whole reservoir of unnecessary correspondence where parties are, before case management hearing, using correspondence to raise issues, or trying to ambush people at the last minute of the case management hearing with issues raised in correspondence on the morning of the hearing. And I'm sure many people on this call will be familiar with that unwelcome correspondence. But taking it all in all, I think case management in the commercial court has been extremely successful. We'd be in a terrible place, and would have been in a terrible place, particularly after 2008, if we hadn't had it. There are other areas of case management, interesting enough, which don't attract much attention. There's a competition list, but when I checked today, there were no cases listed, and there was nothing listed since 2022. There's the Admiralty list, which deals with Admiralty cases, and before the Judicature Act, there was a separate independent Admiralty court that was incorporated into the High Court. And now there's an Admiralty list, and there has been since the Judicature Act in 1877, I think. That's a list which, because of the low volume of cases, actually works very well. There's no formal case management procedure other than what's provided for in the rule. Most Admiralty cases start when somebody arrests a vessel that comes into port and they want it held as security for a claim. But there are more complex cases. And a recent one was a case of the MV Leda Susanna, where Virgin Media sued fishermen from Kilmore Quay who were trawling or dredging for scallops off the southwest coast of Ireland, and they cut the fibre optic cable, the subsea cable, with the dredger, and this gave rise to complex questions. First of all, of jurisdiction, and then in the area of negligence and whether the fishermen had a duty of care. The allegation was that not only did they know that the cable was there, but they particularly enjoyed dredging for scallops around the subsea cables, because scallops love to attach themselves to anything they can find. But this was obviously a major concern for Virgin Media, where it costs hundreds of thousands to fix the cable, and they can be significant outages. But that was a case that was dealt with in the Admiralty list. There were no modern case management rules applicable to it, simply the Admiralty rules in court. But very simple procedures were applied to have early interlocutory hearing on the jurisdiction question, to ensure that there were witness statements, that discovery was dealt with in an orderly way, and that there were good estimates of how long the trial was going to take. There were written submissions dealing with all the issues, and that case was dealt with very quickly. The judge assigned to deal with it happened to be Judge MacDonald, who was also in charge of the commercial court. But it just goes to show that you can have very, very old lists with no particular case management provisions, no fancy rules about case management conferences or what needs to go into a book. And yet by the application of some very simple rules or procedures, you can ensure that a complex case gets dealt with very quickly. I'm just going to finish the talk now on I started with an anecdote about my experience before 2004, when the commercial court came into being. And this is an anecdote about what happened after 2004, shortly after the commercial court had come into being. And when I was still a very junior counsel, I was lucky to be briefed by a solicitor, and the instruction was to try and get the case into the commercial court. And this was back in the day when the judge presiding over the commercial list was very, very strict about everything. but in particular, he was very strict about how the papers were presented to the court and the order that the papers should be in the book. And if there was any mistake ever in the book, this would give rise to, even if it was a minor mistake from memory, this would give rise to a public humiliation on a Monday morning in the entry list. So I was instructed, and the papers were sent down to me, and following my usual diligence, I got round to reading them on Sunday evening, probably a bit late. And when I opened the papers, I realised that something terrible had gone wrong, or something had gone terribly wrong, because first of all, there were pages missing from the exhibits. The book wasn't properly tabbed. There were exhibits missing, and inset in some of the exhibits, there was a letter of advices from Ciaran Lewis BL about the prospects of getting the case into the commercial court, and how the judge might view certain things. And so immediate panic set in. I phoned the solicitor first thing on Monday morning. Solicitor, I should now say, is now a High Court judge. And we had a discussion outside court, and I said, look, this is pretty bad. This judge says that he reads the papers of every case, and we know how he reacts if the papers aren't in order. And the solicitor said to me, well, look, there's two options. You can either fall on your sword and take the beating straight away, or you can hope that when he says he's always read the papers, he might not actually be telling the truth. So we agreed on option B, and I stood up when the case was called, and with a huge sigh of relief, I heard the judge say, I've read these papers. This case should be admitted to the commercial list. And I sat down, and I'm still in practice today, thankfully. So thanks very much for your time and your patience in listening to me. And if anybody have any questions, I'm happy to answer them.
Thanks, Ciaran. Yes, if anyone's got, there's no questions in the chat facility, but has anybody got any questions for Ciaran? I think they're all engrossed in the presentation.
Yeah. They're all asleep. You need to wake them up there, Ian.
Okay, well, if there's no questions, I will thank everyone for attending today. And obviously, big thanks to Ciaran for his time today and for his impressions. I'm sure some of you will know if his impressions there were dead on or not. CPD certs will be with you probably next week now. Still no questions in the chat room, so I think it leaves me to say a very good evening to everybody, and a big thanks to Ciaran again for that presentation. Thank you, everybody.
Thank you.
Thank you.